Welcome to this explainer. If you're a tech innovator, an R&D director, or a global business leader, you are definitely going to want to pay close attention. Because the document we're unpacking today is basically your new strategic playbook. We are going to undertake a systematic, professionally rigorous breakdown of the 2025 annual report from China's Supreme People's Court Intellectual Property Court. And look, I know what you might be thinking, but this isn't just some dry legal text. This is a document that is fundamentally rewiring the global rules for technology, business, and intellectual property. We're going to look at exactly how this court is operating, the unprecedented financial damages they are currently awarding, and how they're actively shaping a landscape where high-value technology is aggressively defended. So let's get right to it.
Here's our roadmap for today. We'll cover 6 main areas. First, the 2025 IP landscape overview. Second, guarding tech and innovation. Third, enforcing fair market competition. Fourth, global IP and fair play. Fifth, effective dispute resolution. And finally, the strategic outlook.
Section 1, 2025 IP Landscape Overview. Okay, we have to start by establishing the sheer scale of what we're actually dealing with here. The volume of high-stakes technical cases handled by this court in a single year is frankly staggering. In 2025 alone, the court received 4,679 technical, intellectual property, and monopoly cases. And out of those, they successfully concluded 3,146 of them. Now, to put that into perspective based on the source data, that concluded number represents an 8.5% increase year over year. This isn't just routine administrative paperwork. We're talking about highly complex, deeply technical disputes that require specialized, expert knowledge to unravel. This sheer volume clearly indicates that as technological innovation accelerates globally, so does the absolute necessity to legally define and defend the boundaries of those innovations. What we're seeing is a judicial system that is scaling rapidly to meet the massive demands of a high-tech economy.
Now, if you only take away one single number from our entire analysis today, please make it this one. Since 2021, the court has awarded a staggering 2.05 billion RMB in punitive damages across 58 cases. That acts as a massive safety net for true innovators. This represents a monumental shift in judicial philosophy. We are seeing a decisive, undeniable move towards severe financial deterrence. In fact, if we look closely at just the 2025 data specifically, in that 1 year alone, 30 cases saw punitive damages applied, totaling 1.13 billion RMB. That is a massive jump from the previous year. The so what here is pretty clear. The court is systematically raising the cost of infringement to a level that will financially devastate bad actors. They are effectively destroying the economic incentive to steal technology in the first place.
Section 2, guarding tech and innovation.
Let's move to our first core pillar. We have this overarching philosophy from the court: ensure true innovation receives true protection. This specific mandate drives the court's actions, ensuring that aggressive R&D investment is fiercely defended against intellectual theft. Now, it sounds incredibly simple on the surface, right? But from a legal standpoint, it is profoundly complex to execute. The court is actively tasked with differentiating between minor, iterative tweaks to existing products and massive, high-risk technological leaps. By zeroing in on true innovation, the judiciary is attempting to incentivize companies to take those big swings. They want you to invest those millions or billions into foundational research with the absolute ironclad guarantee that if you succeed, your breakthroughs will not just be instantly copied by free riders.
So where exactly is the court focusing its protective energy? Well, it aligns perfectly with strategic emerging industries. These sectors now account for 32.4% of the court's entire caseload. To give you some context, back in 2019, these strategic sectors only made up 17.6% of the caseload. So we're looking at a near doubling of that figure, which highlights a laser focus on what they consider new productive forces. We're talking about artificial intelligence and algorithms, high-end manufacturing and microchips, the absolute foundation of our food supply through agricultural seeds, and of course, life-saving biomedicine. The court clearly understands that protecting these specific sectors isn't just about protecting corporate bottom lines. It's about securing national and, frankly, global technological leadership.
And this is where it gets really interesting, because looking at real-world cases proves the court actually has teeth. They are absolutely not afraid to levy astronomical fines to protect cutting-edge intellectual property. Take the glass-shaping tech trade secret case, for example. The court didn't just award standard damages here. They applied triple punitive damages. That resulted in a record-breaking 380 million RMB payout. But they didn't stop there. Furthermore, they ordered the immediate dismantling of the infringing manufacturing equipment to permanently, physically stop the theft. And look at agriculture, a sector we honestly don't always associate with high-tech IP. The infringement of the NP01154 corn seed variety resulted in a 53 million RMB penalty. This brilliantly illustrates that they will utilize maximum legal leverage to defend core technological assets regardless of the industry.
Section 3. Enforcing fair market competition.
Of course, innovation simply cannot thrive in a monopoly. The court is actively balancing the scales by promoting healthy development while simultaneously cracking down on toxic industry involution and anti-competitive monopolies. Now, this concept of involution, or meizhuan, is absolutely critical to understand. In a business context, it refers to a destructive race to the bottom. It's a situation where companies use malicious litigation or monopolistic practices to stifle their rivals, rather than actually competing on the pure merits of their technology. In 2025, the court concluded 49 anti-monopoly cases, specifically targeting sectors like pharmaceuticals and building materials. They are sending a crystal-clear signal to the market. You have to win your market share in the lab, through better engineering, not in the courtroom through abusive monopolistic legal tactics.
And this brings us to a really crucial point about who exactly is being protected. By looking at specific software infringement cases, it is remarkably clear that the court is decisively protecting the commercial interests of private enterprises from much larger monopolistic pressures. There is a deep structural commitment here to the doctrine of equal protection. It simply does not matter if you are a massive state-owned enterprise or an agile private startup. The law applies equally. A great example is the case regarding blood dialysis software. The court recognized joint infringement by the defendants and awarded 22.5 million RMB directly to the private enterprise that actually innovated the code. They are utilizing property preservation and injunction simultaneously to ensure that smaller, highly innovative private companies aren't just crushed by larger competitors who attempt to steal their source code.
Section 4. Global IP and Fair Play.
As we navigate all these new rules, we have to examine the international stage, because in an interconnected global economy, IP absolutely does not stop at the border. So how does this rigorous domestic crackdown actually impact foreign investors and international enterprises? This is the million-dollar question for global business leaders who are either operating within or exporting to this market. If the judicial system is becoming this powerful and this decisive, how does a foreign technology company fare when their patents or their trade secrets are put to the test in this jurisdiction? Is the playing field truly level for everyone?
Well, the answer, according to the court's strict adherence to international treaties, is equal protection. Cases like the Natural Protein 3 trade secret dispute demonstrate a profound commitment to safeguarding foreign technological assets just as fiercely as domestic ones. And honestly, the data backs up a growing international trust in the system. The court has seen an 18.7% average annual increase in foreign-related cases over the past 7 years. That means foreign companies are increasingly and voluntarily choosing this specific court to resolve their disputes. We even see examples in the report of foreign corporate leaders sending thank you notes and videos to the court after securing fair rulings. Furthermore, they are actively protecting the rights of applicants under the Patent Cooperation Treaty, ensuring that any amendments made during international phases are fully respected domestically.
Section 5. Effective dispute resolution.
Next, let's explore how the court actually resolves these incredibly complex, highly technical disputes on the ground. If we break down the 2025 civil data, invention patents absolutely dominate the landscape. Look at that massive segment, 674 civil second instance cases focused purely on invention patents. Now keep in mind, these are not simple trademark disputes over a logo. These cases involve deciphering complex engineering schematics, chemical compounds, and software architectures. To handle this workload alongside plant varieties and monopolies, the court has built an incredible, highly specialized infrastructure. They rely heavily on a national pool of over 1,300 technical investigators. These are actual scientists and engineers who work directly alongside the judges to ensure that legal rulings aren't just theoretically sound but are grounded in absolute scientific reality.
And as this growth trend shows, the court is keeping pace with a massive influx of cases. But they don't just rely on traditional adversarial courtroom battles to get it done. The court leans heavily into what they call the Maple Bridge experience, which is a localized, mediation-first approach. By expanding circuit courts, in 2025, they successfully mediated or saw withdrawals in over 37% of their civil cases to achieve win-win resolutions. Now, what does this matter to you? because mediation preserves valuable business relationships. It allows companies in highly specialized supply chains, like the microchip industry, where the court actually successfully mediated 60 related patent invalidation cases simultaneously, to resolve your disputes, sign licensing agreements, and get right back to business without completely destroying their shared industry ecosystem.
But on the flip side of that, there is absolutely zero tolerance for bad actors. They are actively weeding out bad faith litigation. For example, they completely struck down a fake patent for something called AI bear bile powder because it lacked any legitimate scientific foundation or genuine human creative activity. This is a genuinely crucial element of a healthy IP system, punishing the abusers. The court has zero tolerance for entities that try to patent purely automated, AI-generated junk, or those who forge evidence. They are actively issuing judicial penalties, they're transferring criminal leads directly to the police, and they are outright invalidating malicious patents. This ensures that the IP registry isn't just clogged up with fraudulent claims designed solely to extort legitimate innovators.
Section 6. The Strategic Outlook. Let's bring all these insights together and answer the big so what for business leaders and tech innovators. The overarching message from the 2025 report is completely undeniable. High-value tech will be aggressively defended, and malicious actors are going to pay heavily. We've seen the 380 million RMB fines. We've seen the literal dismantling of infringing factory lines, and we've seen the robust equal protection of foreign assets. So the strategic takeaway for you is this. Intellectual property in this jurisdiction is no longer just a defensive administrative task for your legal department. It is an offensive business asset with massive, strictly enforceable financial value. If you are a company investing heavily in R&D right now, the judicial infrastructure is fully in place to act as an ironclad vault for your innovations.
So I'm going to leave you with a crucial question to evaluate for your own organization. Is your IP strategy rigorous enough to actually thrive in this new landscape of uncompromising protection? You need to ensure your patents are scientifically robust, your trade secrets are hermetically sealed, and your competitive strategies rely on genuine innovation rather than cheap litigation tactics. The standards have been permanently raised, and as we've seen today, the penalties for getting it wrong are incredibly severe. Thank you so much for joining me for this explainer, and keep innovating.